From supplementary list, item number 1.
My Lord, I am for the petitioners in this matter, my Lord. This is in respect of an application for activity bail.
What have you done?
Well, that's the only section.
Is the state here?
Yes, my Lord. I think my learned friend for the state. My learned friend
For
for
the case diary, Mr. Khan?
Not yet, Your Worship. It's still only in the state of motion.
Give us the Supreme Court order. What is the accusation?
379.
379.
Then, my Lord, they've added the Explosive Substance Act, wherein, my Lord, we do not know the reasons why that was added.
All the matter is the same?
It's same. A little, the numbers same, only 2 types of them.
What are the 2 types?
Well, at once is where we had made application, SWA was passed, then Forest had taken the money, that is one part. Other 6 are where we had not done any other thing.
Very good. There will be individual orders. This matter is taken up. The matter is taken up by this bench pursuant to an order of the Supreme Court
On 7th of August.
passed on August 2, 2023.
7th August.
7th of August.
August 7.
Yes, sir. 7th.
August 7, 2023.
Yes.
Paragraph.
I know.
The state is represented. Paragraph. The petitioner apprehends arrest in connection with the illegal co-corporations in the state, in respect whereof several orders have been passed by this bench, pursuant to passed by this bench, full stop. The paragraph, considering the nature and gravity of the accusation against the petitioner, comma, it may not be necessary to immediately arrest the petitioner, full stop. The petitioner will furnish will furnish a bond for rupees 10,000 and a security for equal amount within a week from date
To the satisfaction.
to the satisfaction of
The special judge.
Chief Judicial.
Chief Judicial Magistrate.
Chief Judicial Magistrate where?
Normally it's Nongstein.
Nyongstein.
Nongstein.
Chief Judicial Magistrate West Khasi Hills District. Paragraph. The petitioner will abide by the conditions in section 438 bracket 2 of the Code of Criminal Procedure 1973. Full stop. In addition, comma, the petitioner will be available at the following mobile number. All the mobile numbers you give individually.
To the court or to the court or to the
To the court officer, it will be part of the order.
Right. I'll do
So
that.
that there is no contradiction.
I'm grateful, my Lord. I'll do that.
Full stop. The petitioner will be obliged to disclose the petitioner's whereabouts when contacted on such mobile number. Full stop. The petitioner will not leave the state of Meghalaya, comma, except for going to Assam, comma, for more than 7 days at a stretch without previously informing the investigating officer. Full stop. In breach of any of the conditions, comma, the benefit accorded by this order to the petitioner will no longer apply. Full stop. Paragraph. In the event the state obtains incriminating material against the petitioner warranting his custodial interrogation, comma, the state will be at liberty to apply for cancellation.
I'm grateful.
Paragraph so and so is disposed of.
Apply.
Grateful, my Lord.
Milord, one submission, Milord. One submission, Milord.
Yes, sir.
51A notices have issued 141 notices have been issued to them, and
Sir, we have said 438
their
438 to 1 is covers that area. If you open the criminal procedure report, 438 subsection to 1 covers it.
I'm grateful, Balu. It covers everything on it.
Yes.
My lord, if I can make a small suggestion.
Yes.
I just want to point out, my lord, there is one bail application, my lord, pertaining to the same Shalang PS case number 39, my lord, where same case, my lord, that is pending before the learned single judge. If that matter also, my lord, can be taken up by the full bench,
It's a bail or anticipatory bail?
that is a regular bail.
Regular bail, the order pertains only to anticipatory bail, not to bail, regular bail. Regular bail, the single bench will decide.
Grateful.
From the main list, item number 1.
Mr. Mukherjee,
Yes, Balu.
don't be so happy. The slightest incriminating material will cancel. Yes. Where are we on this? Is any further report there?
Lordship, we filed an affidavit yesterday, Lord.
This is the 16th report.
Lordship, yes,
So you filed an affidavit.
yesterday.
What is the present situation?
My lord, the auction will be completed of about 5 lakh and odd metric ton by end of September, my lord.
Yes.
Justice Kataki has directed certain materials to be furnished to Justice Kataki. We are cooperating with the inquiry
Very
which
well.
is being conducted. by Justice
Pursuant to the 16th report filed by Justice Kataki, Kataki, and the affidavit filed by the state, it is necessary to immediately ensure the adherence to the schedule so that the previously mined coal can be disposed of in terms of the earlier directions, paragraph. Certain conditions have been imposed by Justice Kataki for the process, and certain requirements have been indicated. Full stop, the state should extend its fullest cooperation to Justice Kataki to ensure that the schedule is adhered to and there is no disruption therein. Full stop. In particular, great care should be taken to ensure that purchasers of the previously mined coal do not use the subsequently illegally mined coal, do not pass off the subsequently illegally mined coal and the previously mined coal in course of their transactions. Full stop. Let the matter appear 3 weeks hence for the state report and for state to report. Full stop. A further interim report may also be filed by Justice Kataki. Right now, it's going on. Let that be. There's no major anything new which is there.
Nothing.
To the extent this controls, it will control too. And 3 weeks after that, 4 weeks after that, you do whatever you want. Yes, do you have anything to say, Mr. Hussain?
My lord, in item number 4, my lord.
Yes.
In item number 4, my lord, the respondents, which I add as a respondent, King, and they already get bail in the earlier matter, my lord.
Yes.
But in that case, my lord, I have received some information, documentary information, my lord. I will also file my affidavit.
Please do.
Which proves that there is something, my lord, wrong.
Very well.
Within 3 weeks, I will file, my lord.
Meanwhile, both the state and the state of Assam should cooperate to ensure that The cross-border, the cross-state, cross-state illegal activities are completely arrested. Full stop. Since several persons allegedly involved in the illegal coke plant operations have been granted anticipatory bail earlier today, the state of Assam should assist the state of Meghalaya and the investigating agencies here in monitoring the activities of such persons during the interregnum.
Lordship, may I please, Lordship? I appear in item 2, my lord. This is
Yes.
concerning the export through Gasuapara.
Yes.
I pray for my lord to be permitted to file a short affidavit, my lord, to bring into certain relevant
Very well.
development.
Paragraph, the petitioner in PIL number so and so seeks leave to file an affidavit to bring certain subsequent events on record. Full stop. Such affidavit be filed within a week from date with copies forwarded to the state and the union for both the state and the union to respond thereto.
Lordship, much obliged, Lordship.
Yes. Full bench over. Common order with all the PILs together, like previously, all the cause title, all the numbers, and then the specific, that's why PIL number.
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
Lordship. This item number 1 and 2, Lordship, are analogous in nature. These are against the common order dated 14/8/23, passed by the learned single judge. Your Honor, Your Lordship, my case in brief is this, that in the year 2011 and 12, the petitioner, the appellant hearing are the peons working as a grade 4 employees of the state of Meghalaya. In the year 2011 and 12, there were 60 vacant sanction posts. And the government of Meghalaya has formulated the rules under Article 309, which are called Service Rule 1986. Under that rule, there is only one mode of recruitment of grade 4 employees, that is by way of direct recruitment. Following that process, these posts were advertised, and instead of advertising these posts on a regular basis, these posts were advertised on temporary basis. Lordship, the due selection process was followed. That is to say that there was first written examinations. After the written examination, whoever has qualified, they were asked to undergo written interview. Then after the interview, a select list was prepared by following the reservation policy of the state. And police verification was also carried out. And thereafter, the first batch of the 60 people were given appointment on casual basis for a period of 1 year. 1 year. After expiry of 1 year, Lordship, the state has not issued any formal order that on what terms and conditions these people are allowed to continue. Neither they produce such order before the learned single judge. The fact remains that these people continue to serve the state for a period longer than 10 years. 10 years. Now, during this service period, they were informed by the department in the year 2017, and appointments were made in 2013. In the year 2017, after the expiry of 4 years, these writ appellants were informed that their case for regularization is taken up with the government. And they kept waiting and gave representations on number of occasions. Ultimately, Your Lordship, in the year 2022, they were informed that their regularization can be done only under the RCW schemes, and that too in respect of only those persons who have served for more than 10 years. And it was, we were agreed by that decision of the government. Instead of regularizing the services under the rules, our services were set to be regularized under the RCW schemes.
What is RCW scheme?
RCW scheme, Lordship, for the casual worker, they have formulated the scheme. Under that scheme, the casual worker, and that casual worker is not under the rules, those who are appointed under the rules.
Now, tell us one thing.
Lordship.
Did your letters of appointment say that you were casual?
Yes, Lordship.
Very good. Did you get any provident fund or anything?
Lordship, our pay was increased from time to time.
Pay was increased from
But
but it was a consolidated amount.
Consolidated amount.
It was a consolidated amount.
Yes, Lordship.
You did not have any other additional payments, nor leave in cash.
Later on, they have started giving leave for 7 days.
That's all right. That's thing. and you don't come within the exception in paragraph 53 of Uma Devi.
We come, Your Lordship. We come for the reason that our appointment was as per the due selection process, and we continued for a period more than 10 years. So we fall, Lordship.
It has to be, due selection process is later. First, it has to be, there are regular vacancies. Those regular vacancies are filled up by a due selection process.
Lordship.
And you discharge the duties of the regular vacancies upon completing a due selection process. That's where it comes in. So there was no vacancy. They were taking temporary people without
Lordship,
any vacancy.
that
So therefore, that will not apply. I don't think you'll have much cheer over here.
Lordship, just give us, because there, Your Lordship, that this, there were regular vacant posts, and instead of advertising on regular basis for certain financial constraint which is on record, they have advertised it for on temporary basis.
Mr. General, you entered with your eyes wide open. Having got that on temporary or casual basis, you cannot improve the position. You're lucky you got 10 years. They should have terminated you earlier and undergone the process, but you're lucky you got 10 years. But the fact that you've got 10 years gives you absolutely no right to claim regularization or permanency.
Lordship, they are the initial appointment which was given to them.
Because in your case,
Lordship,
the rigors of Uma Devi were slightly lessened in that Justice Kadju's judgment, but in Dayanand and official liquidator, that has been completely overruled, and Uma Devi's rigors have been brought in with greater force. So therefore,
Lordship, I can understand. I can understand your Lordship. Lordship only will notice one thing. In pursuance, Lordship, if I am permitted to take the advertisement, Lordship will come to page 96.
what has been held by a single judge? Let's come to the
Finding, your Lordship will come to para 11 and 12.
paragraph 11 and 12.
12, first finding, page 286.
Internal page?
Internal page,
We found it.
paragraph, page 285 of the paper book.
We've got it. Thank you.
Paper book. May I read, Lordship?
Yes.
Having heard the learned counsel for the parties, the main issue for consideration before this court is whether the writ petitioner who were recruited for temporary engagement on payment of daily wages would be entitled or eligible to be considered for conferment of permanent status by way of regularization. Though it is correct that the Service Rule 1986 provides for the method of recruitment into the Meghalaya Civil Secretariat and a special rule specifically governing the service of the grade 4 staff. However, that is the reasoning your Lordship given. However, in the advertisement dated 20th/1/2012, under which the petitioners were recruited, there is no mention of the rules therein. That is one reason he has given, but only that the same was for temporary engagement as PM on payment of daily wages. The advertisement being very relevant is reproduced herein below. The advertisement is reproduced, your Lordship. Then I come to paragraph 12. The recruitment of the writ petitioner, therefore, was as per the above quoted advertisement and deholds the rules. Your Lordship, then further it is said, though the recruitment was by way of a written test and interview, there is no mention as to whether this said temporary engagement was against
Absolutely justified, absolutely justified.
Lordship,
Paragraph 16, 17, absolutely justified.
para 11 and 12, Lordship,
Yes,
I was
16,
just reading.
We've gone to 16. They will, without any prejudice to you, consider you under the regular casual worker scheme, but you cannot jump to the regular post.
Lordship, only one thing, Your Lordship, I'll say.
Yes.
That their initial appointment, Your Lordship, if see.
The advertisement is quoted over here fully.
Yes, Lordship, it is quoted.
The advertisement is quoted over here fully. It makes
Lordship.
no bones about the fact that it's going to be temporary. Applications are invited for temporary arrangement on payment of daily wages at rate fixed by the state
But
government.
Your Lordship will see the appointment order.
Yes.
105. Page number 105. The following persons are appointed as casual peons in Meghalaya Civil Secretariat for a period of 1 year from the date of appointment.
Now,
After 1 year, Lordship,
if you are appointed on a regular basis
Lordship,
to a regular post, even let us say casually, your terms of appointment would be scale of this to this, increment of this to this. You are given a fixed amount. You are lucky that you got 10 years service.
Lordship,
They were entitled to, throw you out, so to say. There are times when, say there is some event or there is something which is requires attention immediately. For a temporary period, which could extend to 2, 4, 5 years, the government may need more persons to organize itself. Whereas it does not want to continue that post on a regular basis. Once you create a post, that post remains.
Lordship,
Now, even though there is an equal kind of thing of equal work for equal pay,
Lordship,
but this temporary thing enables some kind of employment to some people who otherwise did not have this opportunity, and also gives the government some kind of latitude in hiring and firing them at will, without going through the rigors of the regular process. This is now accepted, and it's made very clear to you. The fact that you've got 10 years, there's no equity which accrues in your favor.
Lordship, after this expiry of 1 year, on what terms and condition I was appointed, there is neither.
You are free to go away. You are free not to report.
Lordship, I continue, my Lordship, they continue to take my service.
They continue to pay you.
And
They continue to pay you.
They continue
in due
to pay me.
course, 4,000 has gone up to 15,000
Lordship,
in due course, but it's a fixed lump sum amount.
Lordship. Now, that regularization through the RCW Lordship scheme is not even warranted under the rules. It's not warranted
If you
under
don't
the
want that, we'll say that you spun that.
No, Lordship.
You cannot attack the subsequent advertisement.
I just wanted to hear Lordship to.
What does that RCW is, if I don't know that scheme over here, in other states what it does is, these people have no future, they have no severance benefits, so they allow some kind of a lump sum, 1 lakh rupees or 2 lakh rupees to be given at the time of severance, some medical facilities.
Just have a look for 1 minute for RCW scheme 164.
This is a 1996 scheme, RCW scheme, yes.
Page 164.
Yes.
This is the casual master role worker and extension of benefit and regulation of wages. Your Lordship will find that They are entitled, clause 5, when vacancies in Group D post arise in any department or office, 50% thereof shall, subject to rules, order, and the instruction as state government may from time to time issue, be filled up from amongst the RCW working in that department or office as the case may be, and possessing the required qualification. The maximum age limit in such a case shall be relaxed, Your Lordship. Even for, they have, Your Lordship, advertised 77 number of posts recently. Now, if I am conferred the RCW status, as per even this scheme, I am entitled, we are entitled that 50% should be given to this RCW scheme, Your Lordship. And if that is done, at least some part of there are total 57 employees before my Lordship. And they are, Your Lordship, at the lowest rank of the state government employees, Your Lordship, and their qualification is only requirement is class 3 or class 6, and they are not in position, Your Lordship. You know, I'm just, Your Lordship, not trying to gain some pity, but I'm just trying to bring the ground reality, what these people, Your Lordship, are facing, Your Lordship. Then,
Mr. Jindal, you've obtained a benefit. There are many like you who have not obtained even these 10-year jobs. So you've obtained a benefit. There is no right that we see that you can assert. We will observe that the government will consider whether some of them can be absorbed under the scheme, subject to whatever rights. Because what you read, the scheme was subject to orders, instructions, whatever.
yes, that is
It's not an absolute right.
1986 rules, Your Lordship.
The 1996 RCWS rules.
Rules here, these are not the rules, Your Lordship.
There are some 1996 rules for casual workers.
Yes, the 1986 are the statutory rules.
Yes.
Those are formulated under Article 309.
Those statutory rules are not attracted over here. You are covered by the regular casual worker scheme scheme of 1996, not the service rules 1986, and there is no infirmity in the order.
Lordship will, one more aspect to the matter which I would like to, 1 minute.
There is no doubt considerable hardship that you suffer. There is no doubt that you are used to a certain way. After 10 years, you are being thrown out. But, there's no room for sympathy over here because there are many others who are much worse placed than you.
Lordship, only one thing there, Lordship. Had I not undergone the selection process, and here the constitutional scheme of appointment under Article 14 and 15 was duly followed, Lordship. And even our annual confidential reports are raised, and reservation policy is followed, and police verification is also done. They have given a color as if I am a regular employee,
None.
save and accept the payment.
Every kind of recruitment should follow those procedures. We are happy that those were followed and not, some kind of nepotism was adopted.
And another claim, Your Lordship, which I have raised before the learned single judge was that these employees are doing the same kind of job. And this claim was not contested by the state respondent seriously. And I have given the points of similarity between the employees who are engaged on regular basis and the employees who are engaged on ad hoc by following the due selection process, Your Lordship. The finding of the learned single judge on this issue, Your Lordship, is found at para 17, page 291.
Starts from 290. It starts from 290.
Starts from 290, yes. Para 17, page 290. The other contention raised by the writ petitioner as to the application of the principle of equal pay for equal work is of no relevance in the instant matter. A casual daily or temporary employee, such as the writ petitioner, has no scale of pay attached to the post, and as such, there cannot be any claim for any compensation with the regular and permanent staff, wherein a scale of pay is prescribed. This observation is made in view of the fact that, as held in the judgment of State of Haryana and so, the principle of equal pay for equal work is not an abstract one, and for it to be applicable require complete and wholesale identity between the group of employees claiming identical pay scale and others who have already earned such pay scale, and that is for the claimant to substantiate a clear-cut basis of equivalence and a resultant hostile discriminations. The petitioner being appointed and engaged on purely casual basis, independent of the rules, apart from not having demonstrated the factum of equivalence or hostile discrimination, there is no question of principle being applicable in the instant case. Your Lordship, that this observation or the conclusion that the petitioner have not demonstrated the factum of equivalence, is, Your Lordship, is not correct. If I am
Thank you. We've given you enough. Thank you. These two appeals are directed against a common judgment and order of August 14, 2023, passed on two sets of petitions under Article 226 of the Constitution. Full stop. The grievance carried by both sets of petitioners, dash the appellants herein, dash, was twofold, two-fold, full stop. They claim that by virtue of their long service, albeit as temporary peons in the Meghalaya (civil) secretariat Shillong, they were entitled to be regularized under the Service Rules 1986 rather than be considered under the regular casual worker scheme 1996. Full stop. The second limb of complaint was that the appellants herein had been exploited by the state in the sense that the appellants were required to do all duties as regular peons, but were discriminated against and were not afforded either equal pay or equal benefits, though doing the same work. Full stop. Paragraph. Pursuant to an advertisement issued on January 20, 2012, seeking applications for temporary engagement as peons in the Meghalaya Civil Secretariat on payment of daily wages at rates fixed by the state government under the Minimum Wages Act from time to time for unskilled labor, the appellants applied, full stop. It is the case of the appellants that a proper examination was held, following which the successful candidates were called for interviews, full stop. The appellants seek to establish that a thorough recruitment exercise, as in the usual course under the service rules, was conducted before the selection process to the temporary posts was completed, and no appointment was given without obtaining police verification reports, full stop. However, what cannot be missed is that the advertisement was for temporary engagement as peons, the letters of appointment also provided that the appellants were temporarily engaged as peons, and a lump sum monthly amount was indicated as the pay, full stop. The initial appointment was for a period of a year, but the appellants claimed that the state continued to obtain the services of the appellants without issuing any subsequent letter or indicating the tenure or terms of the appellants as apostrophe further engagement. Full stop. It is, however, the undeniable position that from a monthly payment of rupees 4,000 in the year 2012, the appellants received a payment of about rupees 15,000 per month in the year 2022 when the appellants approached this court. Full stop. The two immediate reasons for approaching this court was the issuance of a circular or letter to the effect that the appellants as apostrophe cases would be considered under the regular casual worker scheme 1996, despite the appellants insisting that the appellants had made several representations for regularization of their services and assurances may have been given by the appellants seniors that their cases would be considered favorably in such regard. Full stop. The other trigger, the other matter that triggered off the appellants' ire was the issuance of an advertisement on February 9, 2022, calling for applications for filling up different categories of grade 4 posts in the department. Full stop. Paragraph. According to the appellants, since the recruitment process in the appellant's case was done as in any regular recruitment by conducting a written examination and thereafter an interview, and finally causing a police verification to be made before offering appointment to a person, comma, oh, how does the sentence start? Last. There could be no doubt as to the integrity of the process, full stop. Thus, comma, according to the appellants, comma, their recruitment has to be seen to have been above board and in accordance with any regular recruitment exercise, full stop. Next, comma, the appellants say that they were required to do the same work as the regular appointees, or as would be expected of the regular appointees who may be engaged pursuant to the advertisement of February 9, 2022. Full stop. In respect of, in such regard, the appellants produce some details of the nature of duties that the appellants had to discharge and the duties and work requirements of regular appointees in the same post. Full stop. Paragraph. The single bench held that since the appellants accepted their appointments with their eyes wide open in temporary posts, and the advertisement of January 20, 2012 clearly indicated the nature of the engagement to be temporary, comma, merely because such temporary engagement continued for a period of 9 or 10 years, comma, would give no right to the appellants to assert a claim for regularization. Full stop. The Writ Court noticed that a consolidated monthly lump sum monthly amount was regularly paid to the appellants herein instead of the graded manner of payment to regular employees, full stop. Those certain other benefits, comma, such as some leave, comma, were extended to the appellants, comma, the appellants did not have any further rights as regular appointees. Full stop. Paragraph. Under the scheme of 1996, comma, casual workers who have worked for a certain period of time or who possess the qualifications necessary for regular appointment to the similar post are considered, comma, subject to the age relaxation which is provided in the scheme itself. Full stop. Of course, comma, the scheme recognizes instructions and orders to be issued by the state government to provide for further relaxation to absorb persons who have worked in casual posts into the regular posts, full stop. However, comma, what cannot be compromised on is the qualification necessary for the post, comma, at least the essential qualifications, full stop. Paragraph. The appellants herein were only required to have cleared Class 6 to be eligible to obtain the temporary engagement in terms of the January 20, 2012 advertisement, full stop. There is no immediate indication as to what the essential qualifications are for a Group D post which has been advertised, for the Group D posts that have been advertised on February 9, 2022, full stop. Paragraph. Further, comma, the writ court found that for a claim of equal pay for equal work to be established, comma, the equivalence had to be demonstrated on all counts, full stop. The writ court referred to the principle enunciated by the Supreme Court in such regard and found that the material presented fell woefully short of what was required to what was required in such regard. Paragraph. The essential feature of the matter is, comma, as the writ court noticed by referring to a Supreme Court judgment, was that the appellants herein were aware that they were being temporarily engaged and that their services could be terminated at short notice, full stop. The only basis for the appellant's assertion that the appellant should be considered for regular appointment appears to be the length of time that the appellant spent in the temporary engagement, full stop. Rather than looking at such aspect of the matter from the point of view of how long the appellant served, comma, the appellant should view it as to how lucky the appellants were that their temporary engagement lasted for a period of 10 years and more. Full stop. Paragraph. At the end of the day, comma, considering the strict rules that are now in place for regularization of casual employees, comma, there is no right that the appellants have been able to demonstrate for the appellants to be given a chance under the service rules to obtain regularization, full stop. It will be open to the appellants to accept the benefits that may be conferred to all or some of them in terms of the scheme of 1996, full stop. Paragraph. Since there was no specific right that could be demonstrated before the writ court, comma, such court was perfectly justified in rejecting the petitions by taking relevant considerations into account as evident from the judgment and order impugned, full stop. The order impugned calls for no interference, full stop. Paragraph. Accordingly, WA whatever is dismissed. Both the appeals and the interlocutory applications in the appeals are disposed of. There will, comma, however, be no orders to cause. Paragraph. Despite there being no room for sympathy in this jurisdiction, comma, considering the fact that the appellants have been used to a certain way of life for over 10 years, comma, the state will do well to consider the appellant's case sympathetically under the relevant scheme of 1996. Yes.
Apply.
Item number 3.
For the appellant, you are for the appellant?
Yes.
Yes, sir.
The instant appeal has been preferred against the impugned judgment and order dated 31/12/2022. Passed in W.
Just right to that.
Yes.
Your Lordship, just right now, just I got the file and the endorsed to me.
Yes.
This file is just now just endorsed to me, Your Lordship.
Yes, with you we expect no other submission. We don't expect any other submission. Let us see, you may not be necessary, we may set it aside without your assistance. Yes.
My Lord, passed in WPC number 128 of 2017.
Yes, what was the subject matter?
My Lord, the appellant and others, they were initially working in the competent side of the Assam Rifle, and they approved this honorable court.
Forward. The appeal is directed against an order dated December 13, 2022, passed for the petition under Article 226 of the Constitution. Paragraph, there is substantial delay and there is also an application for condonation thereof. Paragraph, since the respondents seek some time, let the matter appear 10 days hence. In the event that the delay is condoned, the appeal will be taken up for immediate consideration. Full stop. The respondents are put on notice that no further accommodation, on any ground whatsoever, will be considered.
Can it be after 2 weeks, my Lord?
2 weeks.
After 2 weeks.
Item number 4. Item number 1.
Yes.
Lordship, this is a contempt petition
Yes.
of your Lordship's order dated 14th December.
Yes.
Lordship will straight away come to page 34, the directions of which contempt is in.
Page 44.
34.
34. Yes.
Paragraph 11, Lordship. And over the page at 12,
Yes.
Now, admittedly, Lordship, this was to be done by
The
31st of January.
petition is completely without basis. Paragraph, the applicant has invoked the extraordinary jurisdiction for contempt on the ground that certain payments that were required to be made in terms of an order of this court of this matter has to appear before that bench, not before this bench. Anyway, we'll discuss it completely baseless. You take steps, you disconnect the supply, already do whatever.
Disconnected.
But for payment, contempt does not lie.
Lordship, only if I may just,
Since this matter pertains to contempt of an order passed by another bench, let the matter appear before the appropriate bench. Notice this, madam, contempt has to be before that bench, no other.
Item number 2.
This submitted matter appears for further consideration after your lordship's orders of 20th June 2023 and 18th July 2023.
Yes.
There your lordships have expressed the desire that the state should have a relook at the policy and should come back with a report.
Yes.
Now we have received,
Mr. Khan.
May it please your lordship. Lordship, the instruction that I have received is that state is considering that fixation part, lordship, so that there is equity and level.
How long will it consider? Will you consider by the middle of November it would have considered?
Lordship,
All that the state wants to do is get rid of September and October in the middle.
No, absolutely not, your lordship. The instruction that I have received yesterday, your lordship, the department has seized with the matter and has referred to the government.
Very well, next Monday?
At least 2 weeks.
Next Monday. We've given you enough time. From last order was on 18th of July. Next Monday, come up with something concrete, come up with something which will allay the misgivings, and then we'll give you further time. But the basic thing of, placing all the benefits in one hand by depriving everybody else, that you have to
be addressed.
undo. Thereafter, arm's length business, we won't interfere.
Lordship has expressed that. Absolutely.
We won't interfere in that.
Lordship,
That the commercial forces or whatever confederations will take over. But to the extent that you've given one entity all the authority to fool around with, that must be undone.
Lordship, we're trying to bring about that parity between that 8%. Lordship.
Whatever, how you do it is not our concern, as long as the likelihood
of prejudice, yes.
Not the possibility. There may be a possibility, but the likelihood of that is reduced, arrested, or altogether eliminated.
Look, may I just make one submission, since I was also to come back and report. The two aspects which looked at, one was on the question of the margin. No. One aspect of the matter wanted to look at is the margin. Recall the state has fixed, the retail price is fixed. So the retailers get a fixed percentage of 15%. The bonded warehouse people get 8%. What was not fixed is what I am going to get, which is the central bonded warehouse.
What you are going to get, Mr. Banerjee, how you are going to extract that, whether you are entitled to give it on deferred payment basis to some other, on immediate payment basis to some other, and therefore vary the terms and conditions, because as you know, in a commercial matter, deferred payment means another parameter comes in.
Correct.
So therefore, how you tweak the government guidelines to obtain more benefit or to cause prejudice to a party, that is something that we have now been.
May I just, I think something important was missed out, and which I think is very important. I found that today the situation is, my lord, it's not that the central bonded warehouse is, my lord, asking, my lord, directly, my lord, in that sense, what is to be given, my lord, from the manufacturers and suppliers. What is happening, my lord, is the bonded warehouse themselves are getting a permit, my lord, from the state. And then, my lord, the permit is being given to me for us, my lord, to supply to them.
Anyway,
because what is happening...
The state says it's looking into it.
Yes, yes, that's why, my lord, I didn't want...
The state says it's looking into it, but we want the state to expedite that process, and in course of that, the state will be in a better position than us judges to understand what is their fear, what is their apprehension, and to also deal with you.
Yes, but fear obviously, my lord, is that I become now one entity, whether I can influence...
And all these monopolistic practices are available to you to indulge in.
Well, that, well, what was the fear last time?
Why we are saying this is because we are not equipped to understand the nitty-gritties. You will, the relevant department of the state will.
Because, well, I also wanted to, I thought, well, that aspect, well, is very significant, because what is the fear was that, well, I will be promoting some brands or, well, not promoting some brands.
Plus, Mr. Khan, we had benefited with Mr. Banerjee's particular expertise in this field.
Well, expertise, well, is only in one aspect, not one of the aspect of distribution.
Provided you give him the proper taste, he'll be quite an expert.
That is a different aspect. Well, let's not, well, today, well, Tuesday too early, well, in the week, well, to talk about, well, that. But, well, I thought, well, this aspect, well, we also have to consider. That
Tuesday 2 o'clock is not much later than Sunday night 4 o'clock. Or Saturday night 4 o'clock.
Yeah, that is Sunday morning 4 o'clock.
Sunday morning. This apart, your lordships had also identified, my lord, other areas of concern in the 20th June order, my lord, which, my lord, go beyond what Mr. Banerjee is.
They are batting for time. They are just batting for time, and they put up Mr. Khan with his disarming smile so that in these matters...
I think, we'll remember the initial time when we had this matter, was not willing to entertain this at all.
Yes.
And perhaps there's an aspect.
At that stage, they could not indicate to us, they could not explain the matter to us. But now they've been able to...
But I think there is sufficient safeguards which are there. I'll try and also, I'm sure if the state fixes the problem, we are also better off. But we are also better off.
Once the state does that, then you file a writ petition against the state.
Also, they have a percentage. Because in this whole scheme of things, we are actually dependent on what the manufacturer
seriousness in this thing. Except that my length and seriousness on the part of the state, Mr. Khan.
No, Lordship, state is serious. Let me assure you.
You have to take their representatives. You have to understand what their apprehension is. And it's a matter of expertise. It's not what is the actual ground realities. Your personnel will know, they will know, and Mr. Banerjee's personnel will know. We do not know. But we'll broadly see if it kind of takes care of things, makes it a more level playing field, we are happy.
Absolutely, Lordship.
Level playing field does not mean absolutely smooth. It will have a few bumps here and there.
Well, the initial parleys that your lordship had directed between the bonded warehouses and, my lord, the distillers and the, my lord, CBW, well, those have not yielded any result, and thereafter your lordship directed that the state should look into the policy and come up with something more concrete.
It appears to the court that the state may be, yes.
I'm so sorry, there's one affidavit, which we also wanted to put on record. It's a from the 18 June, we'll put that on record, so far as
Please do.
Because that actually shows this position, which I was going to say.
It does not appear to this court that the state is serious in allaying the apprehensions of the petitioners or attending to the several matters that have been indicated in the recent orders passed in the matter. Paragraph. Though the state was required to positively address the issues and come up with a modified scheme or suggestions that would bring about a level playing field, the state seeks further time. Full stop. It is imperative that the state's modified scheme is produced within the next 10 days. Full stop. Paragraph, it is made clear that as long as the state can demonstrate that the creation of a centralized agency does not enable such agency to differentially treat manufacturers, whether by conferring benefits or otherwise, the apprehensions expressed would have been taken care of. Full stop. Paragraph. The modifications or the revised scheme should be presented by way of an affidavit by the state when the matter appears next. Full stop. It will be open also to the, you are the central bonded.
Yes, I'm responding 3, my lord.
It will also be open to the third respondent, central bonded warehouse, to file a further affidavit. Full stop. Just see it's done. We've given you 10 days. When have you fixed after 10 days?
Is it possible, my lord, the 14th of September, my lord?
10 days, I think the 11th or something.
Possible, my lord, 14th September.
It can be 15th or the Monday thereafter.
Then, my lord, may I request for the 18th in that case?
18th, yes. Oh, 18th. 18th, we also fly kites over here.
Oh. I leave it to your lordships.
The 18th is a local holiday over here. So you can come on the 19th.
Yes.
You'll have the advantage of the previous weekend. Long weekend.
Yes.
And that gives you more than 2 weeks' time. So instead of 10 days, give it 2 weeks, since we're giving them 2 weeks' time. 19th September. Grateful. 19th, Mr. Banerjee.
Mr. Banerjee is looking whether it's a Friday or not.
No,
Looking at
that
15th is a Friday.
That week, my lord, beginning most probably 19th, my lord, I might have some personal difficulty, my lord. I have to see or someone, but so, my lord, very well, my lord, can he keeps it 19th? Otherwise, I've requested, my lord, for first week of October, but that might be a little late for me.
Yes. Let's see 19th, if you can arrange your affairs. Otherwise, let your local lawyers.
Not 19th, my lord, if any final, my lord, is hearing out the matter, my lord, I will request, my lord, first week of October to be here, my lord, to at least for my part to finish out the matter. If it still beyond.
Let us come back on the 19th. If the state, my lord, comes up with some modified, my lord, scheme, then we'll have to have a look at it.
Yes, they have to have a look at it. Right. Let the state come up. You may not immediately get a chance. They won't give you advance copies of that.
Right.
So that will give you a chance to come back later in September itself. October will be nothing serious.
First week of October, my lord, 3rd, 4th, 5th. That will still be.
I was only, my lord, let us come back on the 19th. Let us see what the state comes up with. Well, the state will, I would expect they would, my lord, circulate a copy to us.
Very well.
We will do it.
That's all.
Wait.